Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we will discuss the Supreme Court judgment on Section 66A and why it was struck down from the Information Technology Act. To discuss the issue, I have with me Mr. Faisal Farooqi, founder CEO, mouthshut.com, and Mr. Apar Gupta, advocate who specializes in the information technology laws. Now for the headlines. The Supreme Court strikes down the Section 66A of the Information Technology Act, says the provision violates the right to freedom of expression on the World Wide Web. The Act had empowered state machinery to arrest persons for expressing themselves over the Internet. The Apex Court, however, says that the government can block expressions which it feels is a threat to the security and integrity of the nation. The Supreme Court struck down Section 66A of the Information Technology Act. The provision empowered the government with arbitrary powers to harass people for exercising freedom of expression over the Internet. The judgment was given on a petition filed by a law student, Shreya Singhal, questioning the legal validity of the law.
According to the judgment, Section 66A completely violated the right to freedom of speech and expression on the World Wide Web. It held that it lacked the precision and the expression used in it are completely open-ended and unidentified. The Apex Court said that merely to prevent minors access to potentially harmful speech on the net, the Act suppressed a large amount of speech that adults have constitutional right over. It said that such a burden over free speech is unacceptable.
Court has said that irrespective of whatever restrictions you are putting, it doesn't matter whether the medium is internet or the medium is TV. Whatever the safeguards that are provided under the Constitution, that will apply to everything irrespective of what medium it is.
According to the judgment, Section 66A could not be saved on the basis of mere assurance that the section would be administered in a reasonable manner by the government. The court said that governments come and go, but the law would remain forever. The court said that it is not binding that the next government would administer the law in the same manner as the current government. They were of the opinion that vague laws offend several important values. Also, vague laws may trap the innocent by not providing fair warning. They were of the view that to prevent arbitrary and discriminatory enforcement, laws must provide explicit standards for those who apply them. They felt that Section 66A has no proximate connection with incitement to commit an offence, as they found that information circulated over internet not necessarily be information that incites anybody at all. Further, mere causing annoyance, inconvenience, or being grossly offensive or having a menacing character is not offences under the penal code at all.
I think it's a very small piece of a very large war that India is just beginning to fight. And this war is really a war for the soul of India. What kind of society do we really want? Do we want a liberal democracy? Do we want a theocracy? And there's a whole bunch of people who truly do not have any sense of what liberal democracy means. I mean, the framers of our constitution had a sense of it. But they were making huge compromises because they recognized we were still a very traditional society.
The UPA government had introduced Section 66A by amending the Information Technology Act in 2009. The amendment empowered the government to arrest persons for expressing themselves over the internet if it caused annoyance, inconvenience, obstruction, insult, or injury. This led to the arrest of two girls from Thane, Maharashtra, as they posted a comment on a social networking site against shutdown of Mumbai on the demise of political party leader. After this incident, law student Shreya Singhal filed the PIL in the Supreme Court on November 29, 2012.
In a landmark judgment, Supreme Court held Section 66A of the Information Technology Act as unconstitutional. Section 66A was meant to protect from cyber crimes, but it instead gave rise to other forms of crimes. There was a nationwide protest against the section because people believed that the section curbed the right to freedom of speech and expression. With cameraman Chetan, Dipali Pandit for Rajya Sabha Television.
Freedom of expression in the Constitution guarantees to citizens a right to freedom of speech and all forms of expression. writing, speaking, etc., etc., etc. This immediately succeeding clause, Article 19.2, however, limits this right in allowing the state to impose power of law by reasonable restrictions in the interest of the sovereignty and integrity of India, the security of the state, public order, decency or morality, defamation or incitement to an offence. My question to you, Faisal, straight away is, 66A is now out. It's passed, and it has been passed for quite a long time now. The point is, do you think removal of 66A will strengthen the liberal democracy or the liberal society that we want, or let's say a tolerant society where whatever you want to express on the net has to be tolerated in the same manner that the other's expression or opinion? Do you feel it makes it more liberal?
First of all, I think it is a great victory for all of us in this great nation. And I feel 66A truly frees up our country, has made India once again free. I personally feel that 66A was a sword hanging on the heads of every citizen of this country, because potentially आप कुछ भी post करते थे और किसी और को अगर वो नहीं पसंद है तो you could be potentially arrested. And we saw how the language of 66A was drafted. Lekin, by striking it down, the Honorable Supreme Court have once again laid the foundation of this country's tolerant and secular as well as a vibrant democracy, I would say. Because ये आज के लिए law नहीं है. It will be for many, many years and decades to come. We are a nation that fought for freedom from the British rule for more than 200 years. And those great people who finally achieved independence, we are just the beneficiaries. हम उनके शुक्रगुजार हो सकते हैं कि we got that freedom because of their. And they wrote the constitution. And they inserted these articles, 19.2 especially, which guarantees freedom of expression and speech. आज जब सिर्फ टेक्नोलॉजी के वजह से एक मीडियम बदल गया है और आप बोलने के बजाय आप इंटरनेट पे लिख रहे हैं, फेसबुक पे लिख रहे हैं, ट्विटर पे लिख रहे हैं, तो लॉ चेंज नहीं होना चाहिए. एंड आई थिंक सुप्रीम कोर्ट बाय स्ट्राइकिंग इट डाउन हैज सेंट अ वेरी क्लियर मैसेज कि गवर्नमेंट आते जाते रहेगी, सरकार बदलती रहेगी, बट पीपल्स राइट टू एक्सप्रेस शुड ऑलवेज बी मेंटेन. एंड दिस इज व्हाट मेक्स दिस कंट्री ग्रेट.
I'll get you in, Mr. Gupta. Point is, what do you think were the apprehensions of the government? Apprehension of the government because of which it managed to give such a wide-ranging expression or codification like annoyance, inconvenience, insult, injury. All these are very wide terms. What do you think was the government really trying to do by introducing such wide words into the law?
So, if you look at Section 66A, as it then stood prior to Shreya Singhal and is now unconstitutional, it had 3 subclauses. Now, the crux of the offences which were charged essentially was in one subclause which had all these phrases: annoyance, inconvenience, ill will, hatred. Now, what was the problem in this? The problem in this was that when you contrast that to any other existing criminal provision, these were mere phrases as opposed to ingredients of an offence. So, for instance, if you look at the offence of obscenity, under Section 292 of the Indian Penal Code, it defines what obscenity is. It contains a whole paragraph. It does not just merely say that obscenity is punishable as an offence for imprisonment up to X number of years and with a fine. So, if you look at 66A, it would only say obscenity. It would not contain the entire paragraph. This is called vagueness.
Right.
And what happens due to this vagueness when a phrase is not defined well within law and it criminalizes certain conduct? It leads to ambiguity. It leads to a situation that it can be applied in a multiple instances without speaking as to its reason itself. Coming back to your question, Section
So basically,
60
it allows the defining part is left on the judges.
The definitions if in the absence of definition, in the absence of proper phrasing, and just a solitary, isolated phrase which is, then being bundled with, let's say, annoyance, inconvenience, ill will, and hatred, which are all 4 different things. That's why even look at the dictionary. Now, all these 4 different things, if are criminalized by the same provision, it leads to vagueness. And also, it displays that the section does not have a reason. The section by itself is not telling us how it should be applied and what is its reason. And the only clue to this was in fact found in a parliamentary committee discussion prior to its introduction, which was that it was to safeguard spam. Now, this is also a little fantastic. We get so much spam on our phones every day from XYZ companies. Correct. It's never been made criminal. Not only is this disproportionate, but also look at the situation where annoyance and ill will is not limited only to spam. And in fact, experience showed us that how 66 was applied, A was applied. It was not applied to spammers, but to people who engaged in political dissent.
So basically, it was to contain political dissent.
Yes, to a large degree, but it was also a display of state power over a new technology which it did not completely understand. What has the internet done? The internet has freed up the printing press.
Yes.
All of us now have printing presses and multiples of them.
Yeah.
Laptops, phones, everything
system.
Is a printing press these days.
Yeah.
It has democratized knowledge by making us, not each one of us, consumers of news and information, but producers of it. We write so much, it has not been written in the history of man by itself.
Correct.
I have told that...
and all documented.
Yeah, I've told every 1 minute about 9 hours of video is created and uploaded on YouTube. And this is just a fraction. Our information and our knowledge society is growing.
Political dissent and spam.
Political dissent, informed views, high level of communication, which is the bedrock of an open and democratic society.
So basically, it's a very well-written judgment. Very well-written
exceedingly.
judgment. We'll move on. Time for a short break. Coming up next, the Apex Court has ruled that the government can block certain expressions which it feels is a threat to the security and integrity of the nation. Welcome back. The Supreme Court judgment has, however, declared Section 69A of the Information Technology Act as constitutional. This section allows the government to block expressions which it feels is a threat to the security and integrity of the nation. Violation of this law carries an imprisonment up to 7 years with fine. The petitioners has also sought quashing of this law.
The government is well within its rights if it blocks publication of any expression on the grounds that it may hurt the security and integrity of the nation. The Supreme Court said that the definition in this section of the law was framed suitably for the purpose and there is no scope of misinterpreting.
The funny thing is that new laws are being created to restrict our freedom as opposed to grant us greater freedom, which is what you would expect from a maturing society. So 66A, yes, I mean, I'm delighted, but it's a very small beginning of a very large problem, and the problem is in our heads, it's not in our statute books.
According to the Section 69A of the Information Technology Act, the government has the power to issue direction for blocking for public access of any information through any computer resource. This can be done by the government through an authorized officer if it feels that an expression may breach interest of sovereignty and integrity of India, defense of India, security of the state, friendly relations with foreign states or public order. This can be done only after the reasons are recorded in writing by the officer. In an event, if the service provider fails to comply, then he will be liable to be punished with an imprisonment for a maximum term of 7 years with fine.
If you look at 66A, Part A, Part B and Part C, they all suffered from various infirmities. In one subsection, there was no mens rea required, and intention is required for a criminal offence, right? Then in nowhere in none of the section were any of the words defined, you see. So in a criminal provision, you must know the judge for it to apply beyond reasonable doubt that somebody is guilty. You need two things. You need a very clear definition of what is being done that is attracting guilt. And the second thing is that you need a guilty mind.
On March 24, 2015, Supreme Court struck down Section 66A of the Information Technology Act. Validity of this section was questioned by the petitioners. Section 69A was upheld by the court as it defines the procedure and safeguard for blocking for access of information by public. Besides this, Section 118D of the Kerala Police Act was struck down as it was found violating freedom of speech.
Section 66A provided power to arrest a person for posting offensive content on the internet. Due to this section, there were several instances across the country where people were arrested for keeping their view on the social media. Now that the section has been removed from the Act, it comes as a big relief for the citizens of the country. With cameraman Chetan, Dipali Pandit for Rajya Sabha Television.
A total of 7,200 cases or more were registered under the Information Technology Act during the year 2015 as compared to nearly 4,300 or more cases during 2013, showing an increase of nearly 65%. Of the total cases under Information Technology Act, 77% were connected to computer and World Wide Web related offences. Okay, all those facts and data is everywhere, it's available everywhere. My point is to you, Mr. Gupta, and very clearly, fine, freedom of expression must have no bounds. Agreed. How do you ensure that it stops at a point where it doesn't hurt the other? And who regulates that? How do you think should it be done if the government is to be kept out of the ambit of such a fantastic and huge platform as the internet?
I think it has to be done constitutionally. And our constitution gives enough guidance as to what are the specific instances and what is the process to be followed. Now, specifically on section 69A, the court upheld the provision, but there are still some questions which remains.
That's the interest of the state. I am on a larger point.
Yes.
That the freedom of expression should not have any boundaries, correct? Should be read very liberally and etc., etc., etc. But where should there be a line so that it doesn't infringe on the other's right to be disturbed,
Yes.
annoyed, harassed, insult, injury, etc., etc., etc. Who draws that line, and how do you think this medium will have to evolve to draw that line so that when I say something, I should be allowed to say something, but at the same time, it should limit me to a point where it doesn't hurt you?
So, going back to the judgment of Shreya Singhal, it contains enough guidance as to how this new technology, the internet, should be regulated with respect to any kind of speech.
What are they?
The court says that our constitution contains enough guidance, and under
What is it?
Article 19,
Specific.
under Article 19(2), there are specific heads of legislation which the legislature itself can make to restrict our speech. Now, this includes public order, decency and morality, obscenity, defamation, the interests of the friendly relations with foreign states. Now, these are precise phrases which allow the legislature to abridge the fundamental right to freedom of speech and expression.
Can it adopt to the present technology?
The court in Shreya Singhal says yes, it can. It can even create new offences which are only arising on the internet. However, it cannot relax the reasonable restriction standards by itself. So, provisions like 66A, which do not comport to the scheme of 19(2), can still not be done. However, offences such as cyber fraud, online stalking can still be criminalized. The court has made a very well-reasoned distinction as to how the internet should be regulated, and I think it has expounded what was already there in our constitution, that there are certain categories of the legislation which can be made by the legislature again. But however, this legislation needs to not only be substantively within the categories it is allowed under 19(2), but also the process should ensure natural justice and there should not be any chilling of speech on it.
You would like to add to that? See, I should be allowed to say whatever I want to, but it should stop me at a point where you start getting hurt.
I think this is a fairly well settled debate, and as Apar mentioned, that in 1902 those restrictions have been defined, and it's very precise. The language used is very precise. Integrity, sovereignty of the nation, incitement or protection of friendly relationship with our other countries, etc. अगर इसके दायरे में आप रख के कोई भी ऐसा law बनाते हैं which restricts freedom of speech beyond something, the restrictions, and then I think those can be potentially called unconstitutional. And this is, I think this is a great constitution. We have one of the finest constitution in the world. If I can think of something in parallel, would be the American Constitution. But I would still say that, this is my country, this is my land, so I would feel more proud of this nation and its constitution. However, we have to look at the emerging technology of the internet. So one of the other petitions, which was, along with 66A, was about 79.3 rules and the intermediary liability. Is the platform on which you are writing, or the blog on which you are writing, or the social media site, it could be anything today. आज Facebook, Twitter, mouth shut है, कल कुछ और होएगी, आपकी कोई website होएगी, personal site. What you are writing, is that platform liable? And the court ruled very clearly that the platform is not liable. And if you write something and I am offended by it, then the only recourse I have is to go and get a court order, where I have to prove that how something that you have written has hurt me. And that, I think, is very well defined in the laws of defamation, etc. in our country.
So that's largely settled, that the existing way expressions can be regulated
As a Supreme Court itself said in the Judgement Ram case, it should be like a spark in a powder keg, which is that our expression should be so noxious that it should lead to imminent lawlessness, a heightened standard that whatever we say should be like shouting fire in a theatre. In a sense that it should lead to that level of incitement that it transcends discussion and mere advocacy.
So what you're saying is that
And
we have a reasonably good infrastructure of law in place.
Yes.
The regulatory framework is already there.
Yes.
And with 69A being allowed, that adds further credence to it. And together they are good enough to regulate the media, which is seems to have no boundaries, no controls, nothing.
I would say that under 69A, there are still problems which arise because that's the power of blocking of websites. Now, while there is no quarrel with the proposition that the government can have the power to block websites, can block content, but the process which is being followed was also under challenge, and unfortunately certain aspects of it were not properly noticed, in my humble opinion, by the Supreme Court. This included that the orders for blocking of websites would be secret and they would not be published. Now, what is the practical consequence of it? If any order of the government which censors content is not made public, then that order cannot be challenged in a court. And if I cannot challenge it in a court, there is a breach of my natural justice.
Correct.
Not only as an author who may have authored that noxious content, but also as a reader. And let's remember, under our constitution, each reader also has the right to freedom of speech and expression, because without reading, I can't discuss.
On that note, moving on, my colleague Dipali Pandit spoke to Asim Trivedi, cartoonist, who was one of the victims who got arrested for expressing his views through his cartoons.
Mr. Trivedi, you are one of the victims of Section 66A. Now that the section has been removed from the Act, how do you look at it?
सबसे बड़ी बात है कि मुझे मुकदमा नहीं लड़ना होगा और इससे मैं बाहर हो गया, मेरे मुकदमे से ये सेक्शन बाहर हो गया. तो जो भी लोग विक्टिम थे, जिन पर भी ये लगाया गया था सेक्शन, सबसे बड़ी रिलीफ तो यही है कि वो तुरंत इस पूरी कार्रवाई से बच गए. जब आप एक ऐसा कानून बनाते हैं और कुछ लोगों को गिरफ्तार करते हैं, तो एक बहुत बड़ा डर बैठता है बाकी लोगों के अंदर कि अगर वो भी कुछ लिखेंगे सरकार के खिलाफ तो वो अरेस्ट हो सकते हैं. और वो भी ऐसे माहौल में जब देश की युवा जनता धीमे धीमे एक्टिव होती जा रही है, वोकल होती जा रही है, नेशनल इश्यूज़ के बारे में बोलने लगी है, उसका एक ओपिनियन है. कुछ दिन पहले तक हम लोग बात करते थे कि युवाओं का कुछ लेना देना नहीं है कि देश में क्या चल रहा है इस बात से. उनके लिए अखबार बस लिमिटेड होता था फिल्म के पेज तक और स्पोर्ट्स के पेज तक. तो अब अचानक से जब वो वोकल हो गए हैं तो हम एक ऐसा कानून लेके आते हैं और ये मायने नहीं रखता है कितने लोग गिरफ्तार हुए हैं, ये मायने रखता है कि उसका मैसेज कितना बड़ा जा रहा है. तो जब भी हम टीवी पर देखते हैं कि किसी युवा लड़की को पकड़ के पुलिस ले जा रही है, तो बाकी लोग नहीं चाहते कि उनके घर के लोग इस बारे में कुछ लिखें और वो डिमोरलाइज होते हैं। शायद इसलिए बहुत बड़ा कदम था ये, और सबको, जो लोग इसके शिकार नहीं भी हुए, उनके लिए भी बड़ा रिलीफ है।
Do you think that the removal of the complete section was required?
मेरे ख्याल से ज़रूरी था, क्योंकि कई बार सरकार ने कोशिश की, जब ये लोग ये मांग कर रहे थे कि इसको हटाया जाए, तो हर बार सरकार नई गाइडलाइंस लेके आती थी कि अभी इसका मिसयूज़ नहीं होगा, लेकिन कभी भी उससे कुछ फ़र्क नहीं पड़ रहा था और उसका मिसयूज़ लगातार जारी था। और जिस दिन में ये डिसीजन आया है, उसी के एक हफ्ते 10 दिन पहले यूपी में एक केस हुआ था, जब एक स्टूडेंट के ऊपर वहाँ के एक मिनिस्टर ने लगवा दिया था। तो अगर आप ध्यान से देखें तो इसके मिसयूज़ में कोई कमी आ ही नहीं रही थी किसी भी गाइडलाइंस के बाद, इसलिए एकदम ज़रूरी हो गया था कि इसे हटा दिया जाए।
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.